Please, Your Lordship. Your Lordship, I beg to mention item number 8, Your Lordship.
Yes, sir. Any objection?
My lord, I don't have any objection.
On pre-made by the petitioner, this is matter up to 2 weeks.
Your Lordship. Similar prayer for item number 9, Your Lordship.
Here, my lord, I'm for 1 to 5. The remaining are private respondents.
Any objection?
No, my lord, I do not have any objection.
On pre-made by petitioner, not objected to by respondents, this is matter up to 2 weeks.
Duly obliged.
May please, Lordship, item number 10. For the state
The first appeal.
Yes.
Paperwork is ready here.
Pardon?
Paperwork is ready.
Yes, paper book was given. Yes.
It's ready, Your Lordship.
So how long?
2 weeks.
No, anytime, it's okay.
2 weeks.
On pre-made by the respondent. Your respondent?
Respondent number 2 and 3.
Who's one? State.
I'm for the state.
Respondent 2 and 3 not objected to by petitioner. This is matter after 2 weeks. I know 3 weeks. 3 weeks.
Obliged, Lordship.
May I please, Your Lordship? I beg to mention item number 3. Let this matter come after 2 weeks because Mr. Day is on sanction leave.
This is 2017. I think I made it very clear last time.
Yes, Your Lordship, just on the after puja.
You cannot hold on like this. You take up the matter.
Your Lordship, because Mr. Asday is want to take this matter and he's on sanction leave for today.
2017.
We'll do it on the next date, Your Lordship.
What is this matter about?
This is regarding appointment of lecturers in government college.
Oh, that's
Empanelment. They are challenging the empanelment of the respondent number 6 as subject expert in the interview board. Their contention is that the subject expert is not from Garo subject.
Qualification of that.
Qualification of the subject expert. In fact, she is a lecturer in Lady King College in Garo subject. She is qualified.
We'll see what are the parameters required, what are the essential requirement as far as sitting in that board is concerned.
Yes.
For that, why are you taking it, dragging it for so long?
Because Mr. Asday is on sanction leave for today, Your Lordship.
Accommodation has been sought for on behalf of the petitioner on the ground that the Learned Conducting Council is on sanction leave. It may be reminded that this is a long pending matter and the parties should make an endeavor that the matter be heard at the earliest. On consideration of the pre-made, it seems allowed. This is matter up to 2 weeks.
Such a pleasure.
Lord, I beg to make a mention of item 2 of the hearing list. Here actually the hearing is concluded. We have to file the written argument.
You have filed yours.
No, I'll be filing today.
You're filing
my
today?
friend may give me a copy also.
I'm appearing behalf of respondent. I've already filed my written.
You have filed.
So my lord, I'll require some time, my lord.
A week's time will be given.
May come after the vacation, my lord, puja vacation.
Learned counsel for the petitioner has filed the written argument, to which the Learned J, Mr. K.P. Bhattacharya, appearing for the state respondent, has submitted that he may be allowed to respond to the same, for which some time is prayed for. Learned counsel for the respondent 4 has, however, submitted that the written argument as far as respondent 4 is concerned has been filed. On preamble, this is matter after 2 weeks.
Please, Your Lordship. Lordship, I beg to make a mention item number 4, Your Lordship. Lordship, I beg that this matter may come up after vacation, Your Lordship.
4.
And 5 is connected, Your Lordship.
4-5 analogous matters.
On preamble by the petitioner, this is matter after 2 weeks.
Right, Your Lordship.
May it please Your Lordship, I beg to mention item number 6 and 7 to my Lord. Your Lordship, in this matter, we need 3 weeks' time in order to file an affidavit in reply to the rejoinder affidavit filed by the petitioner.
How would you reply to a rejoinder?
My lord,
As per the instruction.
it is pertains to the ACP and MSCP, my lord.
Yes, so
So in that we have a challenge that they have not annexed any copy whereby showing that the petitioner has received the ACP and MSCP, my lord. So they require instruction on that.
oh,
Because in the affidavit in opposition, my lord, not a single piece of the affidavit were showing that the petitioner has received. We have denied that we have not received one.
okay. But in their affidavit, they say that you have ACP has been given to you.
Yes, my lord. So we have denied in our rejoinder, so they want instruction on that.
On that ground, Your Lordship, we need to file an affidavit.
Counsel for the prayer has been made on behalf of Respondent Union of India, seeking time to file a response to the rejoinder affidavit filed by the petitioner on the ground that instructions in this regard have not yet been received from the concerned department. On primate, seems allowed. This is matter after 3 weeks.
Hello.
Much obliged, Your Lordship.
So that is 7.
Yes, Your Lordship, 6 and 7.
6 and 7.
See.
Much obliged, Your Lordship.
Sure.
Supplementary cost list, item number 1.
Yes, what is this?
Lordship, this is a cantonment matter.
Yes, you have to file your counter.
So, Your Worship, I didn't get any instruction yet. That 1 and 2.
How long?
It took up to 3 weeks.
2 weeks.
3 weeks.
Have you filed yours? Have you filed a rejoinder there?
Not yet. We'll be filing.
Mr. Arlebna, Leonard CGC, has submitted that he is yet to receive instructions as far as this matter is concerned to allow the counter affidavit to be filed. Accordingly, some more time is sought for in this matter. The respondent 3 and 4 in the meantime has submitted that the counter affidavit on their part have been filed, which the Land Council for the petitioner has sought for some time to file a rejoinder to the same if so advice. On premier with the parties, this is matter to 3 weeks.
Item number 11.
Tadi makan dulu lah. Where is this?
I think my colleague has just gone to call him. Well, this petition is a revision petition under 397
Yes.
against two orders passed by the learned magistrate. One is for closing the case on the basis of the FR.
But if it is an order passed by the magistrate,
Yes.
the next forum should be the sessions judge.
But 397 is very clear, Malak.
It is, of
Yes,
course. You
yes.
can either appear before the.
Either before the.
But that, you see, in normal course, that should have been your first option.
True. But then 397 has been given either to the district judge or to the High Court. But I'll just draw your Lordship's attention to 397.
Yes,
Yes.
that is.
Lordship is very well aware. Well, a very short point, Malak. FIR was filed on 38/2017, and on 13/9/2017, the magistrate was pleased to direct the police to register the FIR. Thereafter, my lord, to show that I was very much interested in the case, there was a delay on the part of the police to investigate the matter, and accordingly, I filed a criminal revision petition before this court for speedy disposal. And this court by order dated 25/9/2018 at page 21, Mala.
Yes.
This is a short order. Perusal of the records suggests that the report was lodged by the complainant based on which her case was not registered. Confronted with that position, complainant filed an application which was disposed of by the learned GMFC Shillong by order dated 13/9/2017 directing the police to register the FIR and to expedite investigation of the case. The case was registered, copy whereof had been forwarded to the Chief Judicial Magistrate. On receipt whereof the Chief Judicial Magistrate in his order dated 19/9/2017 has observed that in connection with Sardar PS so-and-so to expedite the investigation. Subsequently, complainant filed another application under section 156(3) for directing the respondent police to register the case based on the FIR dated 38/2017. This application has been disposed of by learned CJM by order impugned dated 13/9/2018, noticing therein that the case has already been registered as Sardar PS so-and-so. In addition thereto, has observed that on perusal of records, report is not required to be called at this stage. Investigation is under progress, nothing contrary is noticed therein. The grievance of the petitioner is that investigation is at a snail's pace. It is only in view of the same a request was made to the learned CJM to call for the report. So as to what is the present status of the investigation. The observation of the learned Chief Judicial Magistrate that the case has already been registered renders application under Section 156 CRPC as unsustainable. Once case has been registered, there was no reason to file another instant application with a prayer to register a case on the same facts. Another grievance projected by the petitioner is that the learned CJM should have called for the report as to see what is the progress of the investigation is still open to be looked into. The petition for aforesaid stated circumstances is not worth to be entertained. However, suffice it is to say that the learned CJM on separate motion, if laid, shall, in consonance with earlier direction of learned magistrate, look into the grievances of the petitioner as to whether investigation is progressing properly. Investigation agency be asked to expedite investigation. Dispose of as above with liberty to petitioner to lay requisite motion before the Chief Judicial Magistrate if he so chooses. So pursuant to this order, investigation was taken up and FR under 173 was filed by the police on 3/8/2020. This is at page 32, Madam. I'll just take, there's a very long FR. I'll just take my page 35. Yeah, 35 also. 36. Conclusion.
Yes.
That after much deliberation in the ongoing investigation, last paragraph.
Yes.
Conclusion. It has transpired that the court officials were performing their duties as ordered and appointed by the learned Honorable Court of the Assistant District Judge, Shillong, where they proceeded to the ground floor of the Salonsar building situated at Jail Road, Shillong, to execute the court order dated 24th August 2017, passed by the Court of the Assistant District Judge, Shillong, which had authorized and directed the court bailiff to remove all obstructions or any person who may refuse to vacate the suit premises and if found under lock and key to break the lock open and the door and duly prepared inventory lists of all the items, articles lying in the PO. And since the CCTV cameras installed at the PO were not working, defunct, therefore it could not be established whether the personal belongings of the complainant had been stolen or not. Nonetheless, efforts were made to trace the same, but to no avail. Further, the bailiff requested the son of Paul Leong, namely Kim Pham Marmanyang, to be present, since he had come to the spot to wait till the execution of the order was completed, and the materials lying in the rooms may be taken by them from the suit premises as per the inventory lists. The bailiff also informed Shri Paul Leong that they will provide the copies of the inventory lists, but he did not wait and left along with the others who accompanied them and denied to be present at the suit property, while the inventory of the property was being prepared by the bailiff and the court official. That every possible effort was made to trace the stolen property belonging to Shri Paul Leong from the property, but all efforts proved futile. In this regard, I beg to return the case in FR as true, but insufficient evidence to prove that the case as the stolen property could not be recovered, and I pray Your Honorable Court that the FR of the case may kindly be accepted. The case may be revived as and when any strong concrete evidence is unearthed in the near future. Further, I pray to Your Honorable Court that the alleged accused of the case, Father so-and-so, son of so-and-so, of Bishop House, Limekra, Shillong, may kindly be discharged from the liability of the case. The purport of the investigation of the case has been communicated to the complainant verbally. So what the police has said that it appears to be true, but there is no evidence. What happened, my lord? There was an execution of a decree. Now, of course, this is not relevant for the purpose of this instant case. The Lordship is very well aware that when there is an execution in respect of a eviction suit, notice has to be issued to the tenant, especially the tenant, to remove his articles. that is under 21 Rule 36, if I'm not mistaken, CPC. Here in this case, it was not done. There were a lot of articles inside the premises. So what happened, without issuing notices to the tenant, the bailiff went ahead and to execute the decree. And in the process, when the petitioner, when the judgment debtor came to learn, he went to the site and found that most of his things are missing. And that's what caused him to lodge the FIR. Now that's to the merits of the case. After this order was after this FR was passed, notice was issued to me, to the petitioner. But unfortunately, my lord, at that point of time, the petitioner was suffering from COVID, and in fact, his wife also died due to disease. And my lord, on the first impinge order is at page 40. I am not disputing the fact that notice was not issued to me, but notice was issued to me by the court.
Yes.
Page 40, my lord, this is the first impinge order. Record put up today.
Yes.
Notice that the complainant returned after duly served, but the complainant found absent. On perusal of the case record, seen that the notice has been served to the complainant on several occasions. EOC so-and-so, P. Marwain, to appear before the court on next date fix. Fix 25/11/21 for appearance. Supply copy of this order to the concerned. PI to take steps. So this was the order passed. I'm not at page 41.
Yes.
Record put up today. EO so-and-so, Frangsni Marwing, present and his statement recorded on oath and the same placed on record. On perusal of their statement, it is found that notice was served on informant Shri Paul Leong personally, but the informant failed to appear and filed his show cause on the FR by the IO. Court is of the opinion that the informant is not interested to pursue the matter in spite of receiving notice. The instant matter is hereby closed and stand disposed of. So what the magistrate has done is, because I did not appear, FR should be accepted without any application of mine. Now, what the court should have done, even if the complainant, suppose, does not appear, the court has to apply its mind whether the FR should be accepted or not. And a 174. It cannot say just because the complainant doesn't come, so FR is accepted. That is not the mandate of 174. 174 says the magistrate must apply his mind. But here it would appear that just because the complainant did not appear, the magistrate said it's a fit case to close to accept the FR. Now, thereafter, my lord, at page 42, we filed an application before the trial court.
Yes.
That the complainant had received a notice dated 5/10/2021 on 11/11/2021 from this honorable court with regard to the instant case, whereby the complainant is required to show cause on 17/11/2021 as to why the FR submitted with the IO should not be accepted. That on 17/11/2021, the complainant, as a result of being out of station for his medical treatment after he experienced several health issues while recovering from COVID-19, could not file a show cause, for which he had filed a petition through his counsel on the set date 17/11/21 before this honorable court with a prayer to fix another date for the same. That following the filing of the petition dated 17/11/2021, the complainant was under the impression that this honorable court would fix another date for filing of show cause by issuing a fresh notice to him. However, it has recently come to the knowledge of the complainant that this honorable court, by order dated 25/11/2021, had disposed of the instant case, citing reasons that the complainant was not interested in pursuing the matter. That it is submitted that the complainant is very much interested to pursue this instant case. However, for some reason or the other, the complainant could not pursue the instant case diligently as expected of him due to his continuous bad health condition, including that of his entire family, were also subjected to continuous health complication due to COVID-19. And most important, his wife, who as a result of serious health complications due to COVID-19 expired and passed away. That is submitted that the non-appearance of the complainant before this honorable court on the date fixed was neither intentional nor deliberate, but was caused due to the reason aforestated, and also for the reason that the complainant was under the impression that following the filing of the petition Annexure 1, this honorable court would issue a fresh notice to him. That this petition is filed to bring to the knowledge of this honorable court the mitigating circumstances faced by the complainant which prevented him to pursue the instant case diligently as expected of him. That this petition is filed bona fide and for the ends of justice. Under the circumstances, it is prayed that your Honour may be graciously be pleased to admit this petition, and accordingly, after hearing, be pleased to pass necessary order to allow the complainant to show cause on the final report submitted by the investigation officer in this instant case. This was the petition, Lord. And we have annexed also copies of the medical reports. At page 59, my Lord will find the order passed by the magistrate on that application which I just read. My Lord, the magistrate by this order has said nothing except for the fact that she cannot review her own order. And I also correctly cited the Supreme Court judgment of Surendra Singh also.
Yes.
So, true, my Lord, in respect of this order, I cannot say much because the law is very clear. Criminal court has no power to, the magistrate has no power to recall or review its own order. Now, my only grievances before your Lordship here is that I be allowed to file my protest petition. Because your Lordship will see the order I have read where the FR was accepted. That is completely a non-speaking order, rightly or wrongly. So I'm here before your Lordship is just to allow me to file the protest petition. Whether there's any merits and all that, the magistrate will have to look. I am not asking this court to look into the merits of the case. I'm here before your Lordship only to give me a chance to file my protest petition before the magistrate, before acceptance of the FR. My Lord, a very interesting decision. This is the latest. In fact, it has not been reported yet in the SCC. I've got this SCC online. My Lord, to come to para 10.
This one. Yes.
In fact, 11, my Lord, 11.
Yes.
In view of the above, there remains no shadow of doubt that on the receipt of the police report under section 173 CRPC, the magistrate can exercise three options. Firstly, he may decide that there is no sufficient ground for proceeding further and drop the action. Secondly, he may take cognizance of the offence under section 191B on the basis of the police report and issue process. And thirdly, he may take cognizance of the offence under section 191A on the basis of the original complaint and proceed to examine upon oath the complainant and his witnesses under section 200. It may be noted that even in a case where the final report of the police under section 173 is accepted and, this is important, the accused persons are discharged, the magistrate has the power to take cognizance of the offence on a complaint or a protest petition on the same or similar allegations even after the acceptance of the final report. As held by this court in Gopal Vijay Verma versus so-and-so, as followed in so-and-so, a magistrate is not debarred from taking cognizance of a complaint merely on the ground that earlier he had declined to take cognizance of the police report. No doubt, a magistrate, while exercising his judicial discretion, has to apply his mind to the contents of the protest petition or the complaint, as the case may be. So what the Supreme Court has said, Milord, here, even like in this instant case, even after the acceptance of the final report, because the magistrate has said, no, I have no power. I have accepted the FR, matter stands closed. The Supreme Court said no. Even after acceptance of final report, if I file any petition, the court is bound, the magistrate is bound to look into the merits of the matter. So this squarely covers my case, Milord. This is the latest decision of the Supreme Court.
This speaks of the application of mind of the magistrate at the time when the FR is filed.
No, application of mind is a different. This speaks about even if the magistrate has accepted the FR, even assuming, like in this case. In my case, the FR was accepted because I did not appear, or it could have been accepted for any other reason. But the Supreme Court has said, even after the magistrate has accepted the FR, the magistrate is bound to look into my petition. If I file any petition, a protest petition, or any petition.
Exactly.
Yes.
But that would be after the
FR has been accepted.
Yeah, before the FR is.
No, here is no. The Supreme Court is very clear that even after FR.
Yes, FR is accepted.
Yes.
You have filed your show cause or objection, whatever,
yes.
and the magistrate sits upon it or look into it. Then he can pass an order as to whether it's justified or not.
Or not, yes.
In your case, you have not done so.
No.
So the magistrate has went ahead and passed the final order.
Yes.
So you see, that is going a notch up. At that point of time, the magistrate's hands are bound. The court has passed the order, and he can't go back and review its own order.
Yes.
So we are at that stage.
Yes.
Where the court cannot review its own order, not on the merit of whether the FR is justified or not, or whether your show cause can be considered. Not on that.
Yes.
It's only on the see, when you have come before this court by way of a revision, it attacks the jurisdictional aspect of the matter, or the exercise of power or jurisdiction of the court concerned. If on the face of it, the magistrate has not traverse or transgress his or her jurisdiction, where's the scope for for interference under 397? I think that to that extent we agree upon it. Apart from that, I don't know what else to be done.
My only
you may have a case.
Yes. That is up to the magistrate to decide. I'm not asking this court to look into the merits. Yes.
Whatever the case may be, Mr. Dingro.
Yes.
You do have a window in the FR itself.
In the FR itself.
Where is the FR? The conclusion.
Conclusion is that there is a case.
No, in the where is the
36.
What's the FR is
36.
36. Just that's the conclusion. Look at that observation. You have read it out, of course. It says the case may be revived as and when any strong and concrete evidence is unearthed in the near future. So,
in the near future.
Yes. So the scope is still there for investigation.
Yes. The police have not said that this is a false case or anything. The police have just said that this is true, but we have not been able to unearth
you see, what is your grievance? Your grievance is that the investigation should proceed,
Yes.
and finally the matter to be, to be carried on in due course.
In due course.
Uh,
That
to
would
which,
be
to
that
which,
would,
to
that
which
would,
an FR was filed, and the court has accepted the same. Okay. Now here is an observation which the IO himself says that in case any, if there's any inkling of any investigation or any evidence coming up or cropping up in near future, the case will be revived. So there, you see, you are saved.
Yes.
It is not necessary for you to, even file a show cause.
But my lord, that is
The only thing
speaking,
that the court can also, I don't think you have a case as far as the revision is concerned, because this court, by any stretch of the imagination cannot accept that the impugned order was passed without jurisdiction. Number one.
My lord, the first order, my lord, I'll cite the decision on this issue that the magistrate should apply its mind.
No, application of mine, yes. You have that order, with the decision that you have cited there also.
No, this decision is regarding acceptance of FR. Now, my lord, in respect of application of mine, that is 2019, volume 8, SCC, page 27, my lord, para 27, page 43.
Para
27. Page 43. It is undoubtedly true that before a magistrate proceeds to accept a final report under section 173 and exonerate the accused, it is incumbent upon the magistrate to apply his mind to the contents of the protest petition and arrive at a conclusion thereafter. While the investigation officer may rest content by producing the final report, which, according to him, is the culmination of his efforts, the duty of the magistrate is not one limited to readily accepting the final report. It is incumbent upon him to go through the materials and, after hearing the complainant and considering the contents of the protest petition, finally decide the future course of action to be, whether to continue with the matter or to bring the curtains down.
Again, Mr. Dindo, you see, look at the situation here. In this situation, there is a protest application, which in your case is absent.
Yes.
Number one. On the basis of the protest application or show cause or whatever we call it, then it is incumbent upon the magistrate to apply his mind or her mind, and also to again examine the materials of the court, including whatever is there in the charge sheet or in the investigation report.
But what has been done in this case, my lord will notice, is that just because complainant is absent, FR accepted. That is not expected.
But under the circumstances, what can you expect the magistrate to do?
No, magistrate has to look into the requirement. In most cases, maybe in most of the cases, in fact, no protest petition is filed. Yet the magistrate, they look into the records and said no. The FR cannot be accepted or can be accepted in view of certain conditions. Now here, my lord, this is a case where the petitioner was, it was during the COVID period.
I understand.
All I'm asking from this court is to allow me to file a protest petition, and in view of the recent decision of the Supreme Court, it doesn't mean that just because FR has been accepted, the matter stands closed and it cannot be reopened. That's what the Supreme Court has said. That is the latest decision. Even if after FR has been accepted, the magistrate still has to accept the petition filed by a complainant or a third party to examine the case afresh. So that is all I'm seeking from this court.
Which you have brought to the notice by filing the petition wherewith the latest impugned order was passed. it means that you have brought to the notice of the magistrate your protest. Not that you have filed the actual protest petition, but you have brought to notice that I am contemplating
to file
a protest, which was not allowed.
Yes.
So, based on that, the magistrate says that how can I allow, because
I cannot review. Yes. Which is very correct to a certain extent, Malaj.
So what you should have done is, when the first impugned order was passed, you could have come before the the higher forum or higher court to get it rectified or stayed or whatever, or set aside.
That ought to have been done.
You have not done that. Instead, you have proceeded
Instead, we have filed
before this self-same court.
To that extent, of course, Malaj.
Mr. Shulai, what do you have?
May it please your Lordship. Lordship, kindly come to the prayer made in the petition. Lordship will kindly come to page 16.
Page?
Page 16 of the criminal petition, your Lordship.
60?
116, your Lordship. Lordship, I kindly see, this is the first order passed by the London magistrate, closing the, accepting the FR, your Lordship. Lordship, that order, Lordship will find it at page 41.
Yes.
Lordship, kindly come see. The instant matter is hereby closed and stand disposed of, your Lordship. So 25/11/2021, your Lordship.
Yes.
When did they file this petition, your Lordship? The date is not mentioned. Somewhere in month 2000, in the year 2022, your Lordship. So, Lordship, my first contention is that this application, your Lordship, is barred by the law of limitation, your Lordship. Lordship, kindly see the law of limitation, your Lordship, 131, Article 131, your Lordship. If Lordship is having a barrack, by a universal, your Lordship, that you will find, your Lordship will find at page 34, your Lordship.
Yes.
Lordship has got it. 131, your Lordship.
Yes.
May I read it, your Lordship?
Please.
To any court for the exercise of its power of revision under the Code of Civil Procedure or the Code of Criminal Procedure, Lordship. Lordship, admittedly, your Lordship, this is a revision petition because, your Lordship, 397, I'll come also under 401, your Lordship. Lordship will kindly see 90 days, the date of the decree or order or sentence sought to be revised, your Lordship. So the first order passed by the London magistrate is on 25/11/2021, your Lordship. And this petition was filed after a period of 1 year 7 months, your Lordship. If we calculate, your Lordship, by from 25/11/2021 till 10/8/2022, your Lordship, it will come to 1 year 7 months. Correct? So on this count, your Lordship, the revision petition, your Lordship, is
after 1 year.
1 year, almost 1 year 7 months, your Lordship.
7 months.
From 25/11/2021 to 10/8/2022, your Lordship. It will come around 1 year 7 months, your Lordship.
Yes.
So going by the Article 131, Your Lordship, of the law of limitation, Your Lordship, they should have come within 90 days, Your Lordship. 90 days. So Your Lordship, in view of the law of limitation, Your Lordship, this petition, Your Lordship, is liable to be dismissed. Next, Your Lordship, another point, Your Lordship, going by the case, Your Lordship, kindly come to the FIR, Your Lordship. FIR, Your Lordship, will find at page 19. At page 19, Your Lordship, there is Lordship, I will say that there is a name accused, Your Lordship, that is Father John Madur with 10 people, Your Lordship. Second paragraph of the FIR, Your Lordship.
Yes.
Then Lordship, kindly come to the FR. Lordship will kindly come to page 36.
Just a moment. Page 36.
Lordship, yes. Lordship, that is the last paragraph of the
conclusion.
Lordship, yes.
All right.
Lordship is with me.
Yes, please.
Further, I pray to your honorable court that the alleged accused of the case, Father John Madur, son of so may kindly be discharged. So there is a name accused, Your Lordship.
Oh.
And the investigating officer, Your Lordship, in his wisdom, Your Lordship, during the course of the investigation, Your Lordship, has said that
yes, it is exactly because, you see, it is exactly because the IO has exonerated this particular person,
yes, Your Lordship,
that the petitioner is aggrieved.
Correct, Your Lordship. Correct, Your Lordship. There is no dispute to that, Your Lordship. And then, kindly see, then, Lordship, up page 40, Your Lordship. Page 40, it should be 39. It should be 40, Your Lordship.
Yes.
40, Your Lordship. Kindly see the order dated 17/11/2021 passed by the learned magistrate. Notice to the complainant returned after duly served, but the complainant found absent. He was absent. He was not absent, Your Lordship. Then, Lordship, kindly come to page 41.
Yes.
41, Your Lordship, in view of the absence of the informant, Your Lordship. So the learned magistrate, in its wisdom, Your Lordship, had passed this order, Your Lordship. Had passed this order. So now, Your Lordship.
You see, why this order was passed and how it was passed, the petitioner has explained his stand. He said that he is not, because of his ailment or whatever, he couldn't appear.
So, Lordship, what I mean to contend is done. The FIR, as well as the closure report submitted by the OO under section 173, Your Lordship, reveal the name of one Father John Madur, Your Lordship. Your Lordship, and this person, Your Lordship, the fact remains, Your Lordship, that as on today, Your Lordship, the proceeding against this fellow stand terminated, Your Lordship. And, Your Lordship, he has a right to be heard, Your Lordship, before Your Lordship. By virtue, Your Lordship, kindly come to section 401. Subsection 2, Your Lordship. Because this is a revisional power, Your Lordship. Petitioner has chosen the revisional power of this honorable court.
Yes.
So 397, Your Lordship, will have to be read along with 401 of the CRPC, Your Lordship. Kindly, Lordship, at page 219, Your Lordship, of the BERAC. May I read it, Your Lordship?
You're reading CRPC? Or?
Lordship, yes, CRPC. High Court power of revision.
Yes.
Lordship, kindly see subsection 2. No order under this section shall be made to the prejudice of the accused or any other person unless he has had an opportunity of being heard either personally or by a pleader in his own defense. So, the person who has been sought by the police to be discharged from the liability of the case, Your Lordship, has a right to be heard before Your Lordship. To substantiate my argument, Your Lordship, I would like to rely on one authority, Your Lordship, that is Lordship, this is paragraph 4, Your Lordship. Lordship, yes. In support of the above contention, the appellant have placed reliance on a three-judge bench decision of this court in so-and-so, wherein in the paragraph 48, in the context of a revision against an order dismissing a complaint under section 203 of the code, the provision of subsection 2 of section 401 of the code were interpreted. Your Lordship, in that case, Your Lordship, the complaint has been dismissed. So in this case also, Your Lordship, the FIR, the closure report had been accepted by the learned magistrate. As I have submitted, Your Lordship, there was no proceeding against the person named in the FIR as well as in the closure report. So, Your Lordship, what the Honorable Supreme Court say, Your Lordship, as under, by virtue of section 401 of the suspect gets right of hearing before revisional court, although such order was passed without their participation. The right given to accused or other person under section 401(2) of being heard before the revisional court to defend an order which operate in his favor should not be confused with the proceeding before the magistrate under section so. In the revision petition before the High Court or the session judge at the instance of the complainant challenging the order of dismissal of complaint, one of the things that could happen is reversal of the order of the magistrate and revival of the complaint. It is this view of the matter that the accused or other person cannot be deprived of hearing on the face of the express provision contained in section 401(2) of the code. The stage is not important, whether it is pre-process stage or post-process stage. So, Your Lordship, if Your Lordship comes to a finding, that the learned magistrate has committed wrong, has committed an illegality in passing the impugned order, so, Your Lordship, that proceeding stand revived. So in that case, Your Lordship, the proposed accused in the present petition will have a right to be heard before Your Lordship. Because if it is decided, Your Lordship, that the learned magistrate will have to revive the proceeding, that order will make us prejudice to the accused, Your Lordship. He has a right to be heard, and the petitioner is liable to implead him as one of the respondents in the case, Your Lordship. And in his absence, Your Lordship, in my humble and respectful submission, Your Lordship, no order could be passed, Your Lordship. No order could be passed.
Yes, as far as the revisional procedure is concerned, perhaps 401(2) can.
Yes, Your Lordship.
But if I recollect correctly, the plea of the petitioner here is not for the FIR to be revived or the investigation to be revived. It is for the magistrate to look into the application,
Lordship,
in regard to the prayer.
Lordship, because if Lordship comes to a conclusion that this petition is to be allowed, Your Lordship, in that case, Lordship, the proceeding before the learned magistrate stand revived.
Yes, of course.
Stand revived, Your Lordship. Suppose now a magistrate comes to a finding, no, I'll proceed. So, Your Lordship, in that case, the proposed accused in the FIR as well as in the closure report filed by the police will be prejudiced, Your Lordship. So that is what, Your Lordship, I humbly submit, Your Lordship, that he is required to be heard also, Your Lordship.
Is there any provision for the accused to be heard before the magistrate, looking into the show cause or the protest?
Lordship, so far, no, Your Lordship. But under the revisional power of this court, yes, Your Lordship.
That is accepted.
But before the magistrate, Your Lordship, I don't see any such provision, Your Lordship.
Whether there's an option, whether there's discretion of the magistrate to call upon the accused person to be present, or
Lordship, in the
whether he can
absence
do it.
of such power, I don't think, Your Lordship, that the magistrate will have that power, Your Lordship. In the absence of the power under this application, Your Lordship, because that power is only before this court, Your Lordship, by virtue of section 401 subsection 2, Your Lordship.
True, that is true.
So my humble and respectful submission, Your Lordship, to conclude, Your Lordship, that the order passed by the learned magistrate is perfectly all right, Your Lordship, and the revision petition, Your Lordship, is liable to be rejected, Your Lordship, also on the ground of limitation, Your Lordship, because the main challenge of the order Your Lordship, in the revision petition is the order dated 25/11/2021. The petitioner herein, Your Lordship, had chosen to approach this honorable court, Your Lordship, after a period of almost 1 year and 7 months, and that also there is no satisfactory explanation, Your Lordship, in the petition. It's liable to be dismissed, Your Lordship.
What my learned friend is basically trying to say is that even under 174, even the accused should be, as Your Lordship had put this question, notice should go to the accused. In such a case, my lord, if his contention is to be accepted, then also this order goes, because no notice was ever issued to Father Madhur, who my learned friend says is accused. I don't know whether he's an accused or not, but that will come only after the magistrate is satisfied. I am not asking this court for anything to look into the merits of the matter. That the magistrate will decide. As of now, as on today, no one is an accused. No one is an accused. That is my submission. It is for the magistrate to decide whether to go ahead or not. Magistrate may decide to drop also after hearing me.
Yes.
My only contention
Yes.
is that the order passed by the magistrate that she cannot review her own order goes counter to the decision of the Supreme Court, which says that even after acceptance of final report, the magistrate has to look into my grievances, if any.
What is your reply to the limitation?
No, limitation, my friend, is talking about the earlier order pass. My contention is that this has merged. That earlier order pass has merged with the order dated 10/8/2022.
Where is the order dated 10/8?
10/8, that's 59. Then 2022. That's at page 59. The earlier order passed by the magistrate has merged with order dated 10/8/22, and we have filed this revision in October 22. So it is well within the limitation period. Otherwise, the registry would have rejected my petition. No?
Yes, Mr. Shulai, this order has been, I think 10/8/2022 has also been impugned.
Yes, Your Lordship. Yes. But Lordship, can you see the first order impugned is 25/11/21?
Yes, that is true.
Yes,
that is true. But you see,
it has merged.
But that order has come into focus with an application file before the magistrate, which has culminated or resulted in the order dated 10/8/2022.
Because the order of the magistrate is very clear. Because of the order dated 25/11/2000, I cannot do anything.
Yes, that exactly.
So until and unless that order goes, Your Lordship, it will remain, Your Lordship. It will remain, Your Lordship. So the law of limitation will be is applicable, Your Lordship. It's applicable, Your Lordship. Because Article 131 is very clear, Your Lordship. 90 days from the date of the order. The date of the order is 25/11/2021, Your Lordship.
Where does it say? You see, the date of the simply says the date of the order.
The date of the order, Your Lordship, yes.
Did it say effective order, non-effective order, or
Lordship, it does not say
whatever?
so. Lordship, kindly come to page 34. 90 days.
Yes.
The date of the decree or order or sentence sought to be revised.
Yes.
So
See, order.
here
What is the order sought to be revised here?
is
It is
2511, Your Lordship.
No, it's the order dated 10/8.
No, Your Lordship. Kindly come to the. That's why, Your Lordship, I started with the relief claim in the petition page 16, Your Lordship. Kindly come to page 16, Your Lordship.
Yes.
Lordship,
This is very clear.
Twice and set aside interim order dated 2511.
And
And 10 that is a subsequent order. The main order is 2511, Your Lordship. 2511. 2511 is the main order which is under challenge before this honorable court. And that is why, Lordship, my first submission, I took Your Lordship to the relief claim in the petition at page 16. The first order is to set aside and quash the order dated 25/11/2021, Your Lordship.
But I think, Mr. Shulai, see, the effective order would be this 10/8/2022. Because in this order, what was discussed in this order is the effect of the order of the order dated 21/11.
Kindly see, Your Lordship. Kindly come to page 61, Your Lordship.
Yes.
61. Your Lordship, kindly come to paragraph 14.
Yes.
For the matter was not closed on 17/11/2021 itself. Another date was fixed, and on such date, informant did not appear. So this court recorded the statement of Constable so and so as mentioned above. It is admitted by the informant that this court had accepted the final report and closed the case. So, in view of the above, this court is of the view that this court would pass the order accepting the final report and close the case cannot review its own order, Your Lordship. So, Lordship, the main order is 25/11/2021, Your Lordship. Not this 10/8/22, Your Lordship. Because learned magistrate has washed her hand off, Your Lordship, because of the order dated 25/11/2021. Which he said correctly, Your Lordship, I can't review because of the bar under section 362 of the CRPC.
No, even otherwise, this court has has opined that this order is correct in all respect. It has no jurisdictional error. The same will stand, but we're looking beyond.
Then, if that be, Lordship, my second limb of submission, Your Lordship, then the proposed accused will have to be heard before Your Lordship. Will have to be heard, Your Lordship. Once they are proceeding before the learned magistrate stand revive, Your Lordship, then that will cause prejudice to those people, Your Lordship. Name in the FIR, also name in the closure report. That is my submission.
Yes, you have a point there. But if the FR is not is not accepted or is reviewed, then the named accused automatically is dragged into the proceedings, for which he has to be given an opportunity.
But that stage has not come. My Lord is only deciding.
Can you see that judgment, Your Lordship?
That
the
stage
judgment
has
is very
not come.
clear.
Otherwise, if that interpretation is taken into consideration, that means under 174, not only the complainant, even the accused should get a notice should go to them. If that is the correct interpretation, that means under 174, it's not only the complainant, even the proposed accused, they should be given a notice. Because here, my Lord is not saying that whether to accept the FR or not. I'm not saying that. Here, my Lord is just going to see whether the magistrate should hear me before accepting or rejecting the FR.
We can't say, Your Lordship. We can read the mind of the learned magistrate, Your Lordship, whether he will accept or reject, Your Lordship.
Yes, exactly.
But the fact remains, Your Lordship.
Now you're trying to drag a person who's not even a party to. There's no case pending against him.
The fact remains, Your Lordship, that if Lordship comes to a conclusion as I have submitted, yes, that the magistrate needs to relook, Your Lordship. In that case, as I have submitted, Lordship, that proceeding before the London magistrate stand revive.
Yes, it will stand revive.
Stand revive.
Only to the extent as to whether the FR would be accepted or not.
Lordship, if the magistrate comes to a
if the magistrate comes
to a finding, yes, I'll proceed.
Yeah,
then
if the magistrate comes to finding that, yeah, again you are saying that we cannot, predict the mind of the magistrate. So we don't know whether the magistrate will say yes, the FR will be revived, or will be, will stand as it is, or the case is to be revived. That is not for us to say.
Because Lordship, going by the
we'll have to cross the bridge only when we reach it.
Going by the judgment of the Honorable Supreme Court in that in the 23, which I have cited, Your Lordship, yes, he has a right to be heard, Your Lordship.
Mr. Deva, you can respond to this authority.
Yes,
and my friend also will
because that will change the entire criminal.
Will give me those authority which he has relied, Your Lordship. I'll reply to that.
Otherwise, the entire criminal jurisprudence will change.
Lordship, kindly see.
Well, see, look at as Mr. Shulai has pointed out. Look at the language of this observation. It speaks of the dismissal of the complaint.
Your Lordship, yes.
And what happened thereafter? Perhaps an application for for revival of the.
I'll find out, my lord.
I'll give you this. Then you give me all yours.
And the import of this of the provision of section 4012.
I will supply, my lord.
This will be section 173, 174.
You keep a copy.
Come back tomorrow.
Tomorrow is what day?
Day after, my lord.
Day after.
Yeah, not day after.
No.
Well, let it come tomorrow, my lord. In case, let it come tomorrow.
Not day after.
Let it come tomorrow, my lord.
Day after, I'll have to go for check-up. Then tomorrow, Your Lordship?
Yes. Tomorrow.
Oblige, Your Lordship.
Parties have been heard substantially in this matter. However, on exchange of authorities, the learned counsel for the respective parties have made a prayer for this court to be allowed to respond to the same by countering to be allowed to respond to the same by countering by countering the same with relevant authorities. On permit, list this matter tomorrow.
Oblige, Your Lordship.
For further hearing. Otherwise, I have a mind to dispose this matter, but that is just there's a doubt.
These are important matters. We should be satisfied.
What is the legal implication and the legal effect of this the provision? Try to find out.
Yeah, definitely.